Welcome to the California Lawyers for the Arts live stream on image rights clearance and licensing for publication. Our presenter tonight is Ms. Sriba Kwadjovie. She is the Intellectual Property Manager for the San Francisco Museum of Modern Art, where she manages the copyright and licensing for the exhibition programming, the digital platform, and, if I'm right, the merchandise and publications, correct? All right, so before we begin, please save your questions until the end of the live stream, where we'll have a short Q&A. And let's have a round of applause, and then let's get started.
Thank you. Hello, and welcome to this evening's presentation on image rights clearance, licensing for publications. This presentation is really going to focus on the practical end of seeking clearances for images used in a variety of publications, whether they be books, magazines, websites, merchandise, if that's a possibility, but any kind of print and or digital publication. So to start off, to give a little bit of an overview, many print or digital publications use images to illustrate an argument, perspective, or research. However, using images can present rights and permissions issues. The right to publish a copyright-protected image is owned by the copyright holder. Thus, each copyright-protected image that is used in a publication must have permission, unless it falls within an exception to our current copyright laws. An example of this would be fair use, images found under the public domain, or open access images. So to give a little bit of background as to copyright, which is one of the primary bases for why we seek permissions to use images in publications. We have the Copyright Act of 1976, which is our current copyright law on the books. And the overall premise is copyright is an original work of authorship embodied in a tangible medium of expression. So a creator is one who creates an image or a body of work that is of their own original creation. That creator is known as a copyright holder. They have exclusive rights to their creation, to reproduce the copyrighted work, prepare derivative works, publicly perform the work if it is a music composition, display the work, and publicly perform sound recordings via digital transmission. So that's just a premise or a foundation as to what is copyright and the rights of the copyright holder. So I'm first going to start with the public domain. So artworks in the public domain are generally artworks made in the United States prior to 1923. There may be some exceptions to that rule, but generally speaking, works that were made in the United States, which is very important, where it was created, generally works made in the United States prior to 1923 are considered to be in the public domain. So public domain means that we no longer need to seek permission or clearances from the artist or the creator to reproduce and use them or in any publication. Public domain images can be modified, cropped, overtyped at will. And one of my favorite examples of this is Leonardo da Vinci's Mona Lisa. I think we've all seen many, many different iterations of the Mona Lisa, modifications in a variety of formats. As you can see, the image on your right, the Mona Lisa with her iPhone, taking a selfie perhaps. Clearly this image has been modified for whatever purpose, but the point is this is a work that was made somewhere between 1503 and 1505, so it's pretty clearly in the public domain, and examples of works of this nature can be used freely and at will, and can be modified at will as well. So the public domain, when intellectual property rights expire, to give a little bit more background, often requires research by an attorney or clearance specialist. So we have the indicator of works made prior to 1923 as being in the public domain. As I mentioned before, there are a lot of exceptions to that rule, and if you are wanting to understand a little bit more, if you have an image that you want to use and you have questions about whether this work has been made prior to 1923 or falls in the public domain, really important to seek the advice of a person who is specialized, an attorney or a clearance specialist, to better understand whether the work is in the public domain. A work enters the public domain, may be freely reproduced and modified, as I explained. A work of authorship expires when dedicated to the public domain by an author. So authors can also label their works to be in the public domain, even if it was made after 1923. That is the author can make that determination. Also, Creative Commons licenses. If you're familiar with the Creative Commons, these are works that are where an author has designated a work to be either free of certain rights restrictions, and we'll get into that a little bit later. As I mentioned, the copyright term lapses, or public domain works, prior to 1923. Renewal term is not registered with the Copyright Office, trademark, and public domain rights vary country to country. So that's why it was really important that I mentioned the United States, because depending on where the work, the authorship was made, can also determine the rights around public domain. So some resources that have helped me a lot in understanding public domain images. There is a public domain specialist by the name of Peter Hurdle, and he used to work for the Cornell University, and he created this wonderful chart to help users understand where a work may fall, whether it's in the public domain or how to assess. If you are seeking works in the public domain, a great resource that I often use is the Wikimedia public domain. And there they have a listing of, you go into the website and you're able to find images that are to be in the public domain. And we'll get into a little bit of some things to consider when you are looking at images online that have been labeled in the public domain. Another great resource, and we'll get into this again a little bit more, but museums and libraries also have quite extensive archives of images that have been designated to be in the public domain. And one of the great reasons of going to a museum or library archive is that they have often done the research ahead of time on the works or images of the works in their archive, and have painstakingly determined whether they are in the public domain. And so reaching out to museums, libraries is also a great resource to find public domain images. So getting into open access images. So open access images, such as Creative Commons, Wikimedia, allow content creators to retain copyright while permitting others to copy, distribute, and make certain uses of their work without charge. So again, content creators, that could be any individual who has created an image, can provide open access of that image. One such platform that allows for this is known as Creative Commons, and they attach a Creative Commons license to that content. And it is the content holder or the rights holder that can determine what type of license to attribute to that content. For example, one such Creative Commons license is known as a CC BY-NC 2.0, which is Attribution Non-Commercial. And basically what this means, if a rights holder is designated an image with this license, they're basically allowing users to use this image freely, to share it. You can modify it, reproduce it as you like. However, you cannot use it for commercial purposes. So anything outside of commercial purposes. And when we speak of commercial, namely merchandise, particularly has a merchandise component to it. It can be arguable once we get into promotional use, but typically non-commercial, we're talking about non-merchandise items. So next, licenses are irrevocable until the duration of the copyright has ended. So these are just some stipulations that are attributed to Creative Commons or open access images. Creative Commons is not a party to a dispute that may arise between parties using Creative Commons licenses, so that is also very important to note, that they remove themselves from certain disputes arising should a dispute arise between parties and licenses. And next, users cannot regulate who and how the content is used if the licensee is abiding by the terms of the license. So, as a content creator, you attach a Creative Commons license to some content that you have created, and at that point you have released yourself from being able to regulate who uses the image and how, so long as the licensee is abiding by the terms that you have attributed to the license or to the content. So one big caveat with Creative Commons licenses, and I think this has gotten better over time. Creative Commons is still a relatively new concept. I think it's been around for maybe, 10 to 15 years, maybe even less than that. But one big caveat with Creative Commons content, using that in your publications, is that open access images is that you could be relying on copyright information provided by a person uploading the image, which may or may not be accurate. So one such example that I use, that I find common in my work, is if you come to the San Francisco Museum of Modern Art, depending on the exhibition, we do allow for visitor photography, particularly in our permanent collection galleries. And this has been a relatively new policy change within museums all over the country, is that they are permitting more visitor photography in the galleries. So when a visitor comes in, they take a snapshot of an artwork on the wall, and we don't know how they're going to be using that image. But let's say an individual comes in, there's a copyright protected work on the wall, they snap a picture of it, and then they say, you know what, I would really love to make this image accessible to anyone who wants to use it. I'm going to attach a Creative Commons license to this image. So in that scenario, the person who took the picture owns copyright, as the content creator owns copyright in that photo that they've captured of an artwork or of the gallery or a sweeping view of the exhibition space. However, the artwork that could be depicted in that photo may contain copyright protected content. And in that case, you have to be pretty sophisticated to understand and be able to distinguish that difference. So although the photo of the artwork, the content creator can attach an open access license to that image, there may be additional copyright protected content within that image that the person taking the photo does not have the right to release copyright protection for. So I hope that distinction makes sense. And that has been one of the biggest issues with Creative Commons licenses that is important to pay attention to, that the images that you're using, is there additional underlying copyright protected work within that image that you may need to seek clearance for, even if the image of itself is an open access image. Okay, so we're going to touch a little bit on fair use. I'm not going to go into too much depth, but this does come up quite frequently, particularly with scholarly publications, publications that are really the primary purpose is to educate or provide a critique or commentary using an image to illustrate a point of view. So what is fair use? I'm sure we're familiar with this term, but fair use is a legal concept that acts as a defense to copyright infringement that is intended to promote public discourse by limiting an exclusive monopoly of copyright owners. So the four main principles of fair use, and in evaluating whether a particular appropriation of a copyright protected work may fall under fair use, we're going to look at the purpose and character of your use. What is the purpose of using this copyright protected image in the publication or the content that you are producing? What is the nature of the copyright protected work? The amount and substantiality of the portion taken. How much did you use of the copyright protected content? This gets into my own personal work. We often look at how big are we reproducing this image? Is it going on a huge building banner, or is this really just a thumbnail to make a small illustration of a point? So how much of the copyright protected content are we using? And lastly, the effect of the use upon the potential market. And that's really about the copyright owners. Are we infringing on the copyright owners' potential to promote and to obtain a monetary value from this work? By using this copyright protected image, are we preventing them from making and exploiting their own use for their advantage? And so there are some cases, some case law that goes into a little bit more about fair use. The Kwadjovie prints. I'm not going to discuss these cases in this presentation, but if you want more information about fair use in publications, there's a great resource. It's the fairuse.stanford.edu, which provides a really great overview of fair use and appropriation of content in publications. So some limitations and fair use. These are some factors that you're going to want to weigh when looking at content that you are appropriating for a certain publication. The balance between the exclusive rights of the copyright owner and the user. Again, the amount and kind of material used and the size and resolution of the published reproduction should not exceed that appropriate to the objective. So again, really evaluating what is the purpose of using this copyright protected work. Is it for an analysis? Is it for a critique? Is it for education? Is it a parody? Is it being used as a parody? Really looking at how the nature of the use. Next, the justification for use and the amount should be considered especially careful in connection with digital format reproductions of digital works, and that's exclusively going towards the reproduction of digital-born artwork. So is it going to diminish the originality in reproducing the digital-born content? Is that going to reduce the originality of the digital work? Reproductions of works should represent the original works as accurately as can be achieved. So where you are using content, an image, where you are using or reproducing an image or some content, you really want to reproduce it in its full view. So that is without cropping or overtyping or modification of that image. And provide attribution where possible. That is really, really important. in the digital age that we live in and social media, we see such a proliferation of images and imagery coming through our streams and feeds, and we really don't see much attribution always being connected with that content. Where you are appropriating images and using it for commentary or criticism, it's really important to provide attribution whenever possible. Who is the author? Who is the creator? And attach that. It could be a courtesy of wherever you found the image, but providing attribution is also a very important aspect of this process. Same approach applies to the use of film stills. So I get a question a lot, like I get this question pretty often in my work. Can we use this film still to illustrate a critique about a movie that recently came out? And applying similar approaches with images, you can also apply with film stills. Using images taken by you. So in a photographic work, there may be two underlying rights. We talked about this a little bit earlier. Photographic rights and rights to the content in the photo if present. So again, you take a picture of a Matisse in an art gallery. You may own the photo. However, there may be some underlying rights to the artwork that are not owned by you. If you have a photo of a work in the public domain, then you may use it freely because rights to the photo belong to you. So, again, I like to use a lot of examples of artwork. So, you go into a museum, maybe it's the De Young, and they have quite a large collection of more historical artifacts, which are arguably in the public domain. You take a picture of the plate or the spear. That work would be considered to be in the public domain, and that image of that work may be used freely. If the photo is of a copyright protected work, then rights permissions may need to be sought depending on the type of usage, unless it is fair use. So a little bit about publicity rights, because this comes up also with images either taken by you or images that are found online that may have people in them. As a person, you own the right of your own publicity, and it is not to be appropriated by third parties without your permission. So in California, we have a right of publicity that is governed by the California Civil Code, Section 3344, which is the living person statute. And we also have the California Civil Code, Section 3344.1, which is a postmortem statute. It's important to note that the right of publicity is governed by state law. So depending on the state that you're in, that state will govern how rights of publicity are governed. And I did like to include, if you notice, the background image. This is an artwork by Andy Warhol. It is Triple Elvis. And this is a work that has recently been on view at SF MoMA. And one interesting, some interesting issues that come around this particular artwork, and depending how we plan to use it, if we're using it for a promotional purpose versus more educational use. But there's a lot of components. So one is it's an Andy Warhol work. So we have the owner of the artwork, which is Andy Warhol. So we have his copyright that we have to be mindful of, and we also have the image of Elvis Presley, who was a well-known celebrity. And Elvis Presley still retains ownership in his publicity, even in death, because he died in the state of Tennessee, I believe, and Tennessee does have post-mortem statutes within its, does have a post-mortem statute. So if we choose to use this image in a for promotions or merchandise, there's often a two-part clearance that we are obtaining, not only with Andy Warhol, but also with Elvis Presley's estate for the use of his publicity. And then I can also mention that there may be photographic rights attached to the image of the artwork as well. Chances are that we took a photo of the work in-house, so therefore the museum owns the copyright to that. But if we had found this image maybe through a different source, maybe we obtained it from a third party, there may also be photographic rights that we would have to clear as well, in addition to the copyright owned by Andy Warhol in the full embodiment of the work, and as well as Elvis Presley's publicity rights. So that's kind of a three-part. So right of publicity versus right of privacy. An individual has a right to control others' use of her identity for commercial purposes. Unauthorized use of a person's identity for news reporting and entertainment may be protected by the First Amendment under a balancing test. The balancing test will evaluate to what extent is the use of the person's identity transformative, giving rise to significant creative, expressive elements beyond mere celebrity. And we're also going to be evaluating the public versus private capture. So how do we take this photo? Was it taken on the sidewalk versus a private capture of a portrait, perhaps, taken privately? And we also have to look at the right of publicity after a person dies. And as I mentioned before, rights of publicity are governed by the state, often in which the person has deceased. So you will need to look at that state statute to see if rights of publicity survive after a person's death. So searching for images. If you are looking for images for your publication, there are quite a variety of platforms that you can search to find images. Museums, as I mentioned, museums, libraries, and archives have collections of works in the public domain. The Metropolitan Museum of Art, not that long ago, maybe a year or less ago, just released, I think, approximately 300,000 artwork images into the public domain. And many other museums, such as LACMA, the National Gallery of Art, also are repositories for an extensive collection of artwork in the public domain. And reaching out to these museum institutions or the Library of Congress, for example, for artwork images can be a great resource for images in the public domain and may not have additional fees. Although some museums, it's important to know, some museums do charge a fee for acquiring an image file of a work in the public domain, but it depends. And a lot of times I think they state that is because of administrative fees, or maybe they have to go into the gallery and recapture the artwork image before providing the image file, and so therefore they charge a fee for that use. There are also companies with extensive image libraries or stock images that can provide both a high-res image file and a license to use the image in a publication. Licensing fees can be substantially higher through these companies, however, but you may be able to receive a reduced fee for image use pertaining to scholarly uses. And we'll get into a little bit about what some of the details that's important to note when you are seeking or when you are making a request to a museum or even an image license or a stock image company, what to include, why are you requesting this image? Is this for scholarly use? Is this for promotional use? Fees may vary depending on how you are planning to use the image. Some other great resources for stock images: Art Resource, Bridgman Images, Getty Images, and iStock. And again, these are image licensing companies with a database of images. They may be more expensive than reaching out to a museum, but they also have quite a trove of images to select from. So lastly, this is a slide dedicated to just some details of what to include when making an image request, whether you're reaching out to a library or a museum or a company such as Getty Images. It's really important to include why you need this image and what is it for. Is it for print or digital use? What is the project title? What is the project type? Is this will the image be used for merchandise, or is it being used in a blog post, for example? Who is the author of the project? Is it yourself, or are you requesting on behalf of someone else? The date of publication is always helpful to have, or a roundabout date. Who the publisher is. The languages. If you plan to use the content in additional platforms or on platforms in different languages, that is also helpful to know whether it's going to be English, English and French, English, French and German, and so on. The print run, if it's a print publication, always helpful to know what's the quantity, how many times is the content or the image going to be reproduced in a book, for example. Are you 1,000 copies or 50 copies? And also the area of distribution. So when we say that, where are you planning to disseminate this information? Usually if it's going to be on a digital platform, the default is worldwide, because websites, as we know, can be accessed from all over the world. Or if it's a book or magazine publication that has a limited distribution, primarily maybe it's just for California or North America or North and South America, whatever the area of distribution is, it's also really important to provide that information, because that could determine the fee for the image being used. It's important to note as well that images used on the cover of a book or publication may require specific permission and invoke higher fees. So in my line of work, we often create exhibition catalogs, and the cover of that catalog may have an image on it, an artwork image. That is usually maybe a separate request or a very specific request for the use of the image on the cover of the book. And another thing to note as well is that usually the use of images on the covers of publications may include some kind of cropping or modification or overtype with the title of the book. And usually in those situations, you do need to note that so that the rights holder is aware that you may crop or overtype across the cover of the image, and perhaps exceptions can be made in that case for that type of permission.
Thank you very much for watching. If you would like to see more videos by California Lawyers for the Arts, please like and subscribe to CLA's YouTube channel so we can provide full-service live streaming programs soon. Our channel will be producing videos that cover all kinds of artistic, entertainment, and intellectual property legal issues. You can also find our videos on Facebook and livestream.com.